Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we have a case from the Florida Court of Appeals that we're going to talk about. So, join me down at the beach as we talk about the case of King versus Farah and Farah. Today we have an interesting case report out of Florida, and it comes to us from the 5th District Court of Appeals, and it involves a legal malpractice claim. We recently had a case very similar to this where the court issued an order that was essentially drafted entirely by the other side. And we felt that that was inappropriate and that it called into question whether any judicial power or judicial discretion had actually been engaged. So we thought that we should have gotten a different result, and ultimately we did get a different result at the Court of Appeals, but the Court of Appeals studiously avoided that dealing with that issue. In Florida, however, they did not studiously avoid dealing with that issue. Let's take a look.
Versus Farah and Farah, again, also Eddie Farah and Charlie Farah, who are apparently two brothers that practice law together in the 5th District of the state of Florida. So this is a per curiam opinion, and a per curiam opinion generally means that no particular judge feels like they need to sign this opinion, but rather this opinion is sort of the collective decision of the entire court and is unanimous. And of course, no one dissents from a per curiam opinion either. It says this case involves a claim of legal malpractice related to an underlying negligent security action for which Terrell King claims he sought legal representation from the law firm of Farah and Farah. The trial court granted the law firm's motion for final summary judgment, adopting verbatim the proposed order the law firm submitted. Now, why would that happen? That would happen for a couple of reasons. One, it's a summary judgment motion, which means basically that there are a lot of facts that were entered into the record, and some of those were undisputed facts, and some of them were probably hotly disputed by the other side. And one of the reasons that legal malpractice claims are so very difficult to prevail on is that you have to win the trial within the trial, which means if the original claim was against XYZ Hospital for medical malpractice and you lost that case due to the negligence of your attorneys, you have to show that but for that negligence, you would have won that case. That is a very big hurdle to jump across. In looking at this, they say we do not address and take no position on the issues in the appeal, the issues that go to the substantive merits of the appeal, because they agree with King's overarching argument that the trial court's wholesale adoption of the law firm's 40-page proposed order under the specific circumstances of this case does not show independent judicial analysis, thereby requiring reversal. Well, one of the reasons this is so interesting to me is because I had a case in Missouri recently where the other side got to submit an order to the court on a motion, and with the exception of one sentence that got taken out by the trial judge, everything else in that opinion was written by the defendant. And we felt that did not show independent judicial analysis. And in fact, we raised those claims. The court more or less ignored that and ruled on other grounds. But the fact is, when someone submits a proposed order, it has to be the order of the court. In other words, it has to show exactly what the trial judge would have done if he had done it independently. And as you might guess, when you have one party or the other party writing the judgment, what you have is a case of advocacy more so than a case of independent judicial rulemaking or fact-finding. So the court goes on to discuss a case called Perlow versus Berg-Perlow from 2004, which was a Florida Supreme Court opinion. And in that case, they had a 25-page proposed final judgment, creating an appearance that the trial judge did not exercise independent judgment. In doing so, it considered a number of factors that are relevant in making this determination, such as the length of the detail of the proposal, whether the parties were given an opportunity to object to each other's submissions, how long it took for the trial judge to adopt the proposal, and whether the trial judge made findings of fact and conclusions of law on the record to guide the parties' preparation of their respective submissions. So normally what happens when you have a summary judgment hearing is the party that's moving for summary judgment gets up and says, "This is why I'm entitled to summary judgment." And they go through all of the facts, and the judge will ask questions about facts that he might have questions about. And then the other party will get up and say, "This is why you shouldn't grant summary judgment." And they'll go through their facts. They will show why they don't think summary judgment should be entered. And of course, the judge will ask them questions and try and pin them down on things. And at the end of that, then the court has to review the entire record and issue findings of fact and conclusions of law. For example, let's say the issue is negligence. The court would have to find that there was a duty. Let's suppose you had a summary judgment case involving negligence, where one of the issues was there a legal duty? And the situation was that there was a hole in a lawn. Somebody had dug a hole to plant a tree, but then didn't get around to planting the tree. And that night, a neighbor was walking up to the house, walked across the yard, fell in the hole, and broke their leg. Well, the question would then be whether the condition was open and obvious. If it was, then there was no duty to preserve, to protect anybody from it. And also, they would have to determine whether or not a reasonable person would take precautions against that. So the findings of fact would be that there was a hole, that it was open, that there were no barriers around it, that it was in an area of the yard that wasn't lighted, and as a result, anyone walking in that area could very easily have fallen and been hurt. And that's exactly what happened. So the court, having found those facts, would then issue a legal conclusion that the plaintiff was owed a duty by the defendant. That's a finding of fact and a conclusion of law. Well, in a legal malpractice case, there might be 200 or 300 facts that would be relevant, and there might be just as many conclusions of law that would be relevant, and it would probably take a 40-page order to go through all of it. But the problem is that the court never gave them any direction. And in fact, what really stood out about this case is that the trial court took 6 months to get to this order and confirmed the wrong standard for summary judgment and included language that could be interpreted as overly harsh and injudicious, meaning he probably criticized one of the parties in a way that a judge normally would not do. Then, and it says more importantly, the trial judge specifically instructed the parties not to allow one another to see their proposals. "I don't want your proposed orders sent to each other." I have to tell you, I have never seen a trial judge do that, and I don't think it would be appropriate to ever make that order. They're going to come directly to my judicial chambers, and I don't want you responding to each other's proposed orders. Now, it could be that he just wanted to reduce the paper workload, but that was an improper way to go about doing it. And then the court says, as it was stated in Perlow, appellate courts understand and appreciate the fact that a trial judge in these cases can benefit from proposed findings, but such proposals can serve as a starting point and a reminder of the facts and issues that should be weighed by the judge. That said, it warrants emphasis that such submissions cannot be a substitute for a thoughtful and independent analysis of the facts and issues and law by the trial judge. So the court then goes on to quote this Perlow case, and it says, when a trial judge accepts verbatim a proposed final judgment submitted by one party without an opportunity for comments or objections by the other party, there is an appearance that the trial judge did not exercise his or her independent judgment in the case. This is especially true when the judge has made no findings or conclusions on the record that would form the basis for the party's proposed final judgment. And I would point out that in my case, that's exactly what happened. Because the trial judge adopted the law firm's proposed order word for word, without allowing objection by King's counsel, and made no findings of fact or legal conclusions to guide the parties in preparing their orders, we conclude that independent judgment does not appear to have been exercised as Perlow and our precedent require. The appearance of impropriety exists when a trial judge adopts verbatim one party's one-sided final judgment, especially where the judge did not orally announce findings or rulings during or at the end of trial. We therefore reverse and remand for further consideration to include a thoughtful and independent analysis of the facts, issues, and law by the trial judge. Reversed and remanded. And so all of the judges in the 5th District Court of Appeals affirmed and concurred in that judgment.
I don't always agree with the Florida courts. I think they're absolutely wrong about 90% of the time on insurance cases. And I think that in some constitutional questions, they sort of boot the football too. But the bottom line is that they do write opinions and they do put those opinions out. And if somebody wants to take it up to the Supreme Court, they can. I think that in this case, they've absolutely nailed the issue perfectly. If a judge doesn't take the time to edit an order and make sure that it contains his thoughts, then he isn't doing his job. I'll give you a perfect example. I get stuff all the time from other lawyers, and they're asking for my opinion and asking me to edit their work. And I have never seen a document that somebody sent to me that I could not do better, that I could not make better in some way. And I would think that a judge would feel very much the same way, particularly in a long order. I would think that the judge would want to make certain additions and corrections and add his own opinion in with the other thoughts that were offered by the parties. And of course, probably even more important than that, I would never believe that it would be appropriate for a judge to tell the opposing parties not to share their proposed orders. And the reason for that is quite simple. If you don't share the orders, first of all, it's possible that somebody makes an error that you could call their attention to. In this case, the proposed order had the summary judgment standard wrong. And I can guarantee you that if that was the situation and I saw that as an opposing attorney, I would call it to the attention of the court. And of course, I would also call it to the attention of the opposing counsel. So it makes good sense to have everybody's work reviewed. But, the more eyes that look at something, the more likely you're going to get a document or an order that comes close to perfection, if not actually hitting that mark. So that's what I have for you today. This is a shorter than usual video, but hopefully you found it interesting. I think the Florida Court of Appeals really got this one right. If you have the opportunity today, go out and do something nice for somebody. Today, for example, I took my wife lunch and I fed all the girls at the office sandwiches and salad, and we had a good time eating lunch together. Again, you can't do something nice for somebody else and not feel great at the same time. And on the way out of there, I stopped by a lady who pulled up a sign that said she was homeless, and I gave her $20. Now, maybe she's going to go buy beer. Maybe she's going to go buy cigarettes. I don't know. That's between her and Jesus. For me, I felt better because I had the opportunity to make somebody else feel better. Thanks again for watching. Come visit me down here again at the beach next time.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.